afternoon, ladies and gentlemen here in Indonesia. Selamat siang and selamat pagi. Good morning for our guests and participants from Netherlands. It is my pleasure to
Good
welcome.
morning, all the speakers and
I will
all the
chair this
participants.
online seminar. I hope you enjoy this interesting topic in legal education. I'm Radian Salman, lecturer at Faculty of Law Airlangga, and also person in charge for organizing a program what we call as legal education, ethics, and professionalism, or LEAP, under a scheme of Orange Knowledge Program. Uh, this online seminar is conducted by Faculty of Law Universitas Airlangga in collaboration with Faculty of Law, Maastricht University, and 5 partners law school in Indonesia from Universitas Trunojoyo Madura, from Universitas Halu Oleh, from Universitas Borneo Tarakan, from Universitas Mula Warman, and Universitas Nusa Cendana. Webinar topic today is always important and relevant for legal education because case law is an integral part of study of law. But how method we use in teaching and how it is developed in our curriculum and how our graduates ready into a legal profession with skill based on study based on case law, let's have discussion about it. Here we have expert and experienced speaker to discuss about it. First, Professor Takdir Rahmadi, Honourable Justice of Supreme Court of Republic Indonesia. He is expert in environmental law. And we have Professor Smits, Dean Faculty of Law, Maastricht University, and expert in contract law. And Pak Iman Prihandono, Ph.D, Dean Faculty of Law, Universitas Airlangga. He is an expert in international law and human rights and business. And also we have here some guests, not only from Faculty of Law, but also from many parts of Indonesia. And I think especially I would like to welcoming Roel van der Even from the Dutch Embassy join with us today. And I think I see here many, some of deans from Faculty of Law in Indonesia. Yeah? Thank you for joining this seminar. I would like to credit my thanks to our speakers, and it is an honor for us to have all of you here. Before starting to the main topic of webinar, as it is part of the LEAP OKP program, I would like to invite Professor Awi Haringga to give opening remark for webinar online. Professor Awi Haringga, time is yours.
Dear guests, thank you very much, Radian, for your welcoming words. Wonderful as ever. Well, it's of course our pleasure as the LEAP OKP team and organizers to have organized this webinar on such a wonderful topic, relevant topic, changing over time, but still very relevant and important to be discussed. So there's not really much I can add to what Radian already said. So I suggest we go and listen to the 3 speakers. I'm very happy to have such honorable speakers on board. So I suggest, Radian, we give it a start. And I hope we also have plenty of time for discussion and question and answers later during the seminar. And I wish you all a wonderful meeting for this morning for the Dutch people and wonderful afternoon for the Indonesian people. Thank you very much.
Thank you, Professor Awi.
Okay. If I may, just one remark from the Netherlands
please.
Embassy.
Yes. Yes.
I'm very happy to be in the webinar, and I think it's great that we have this kind of cooperation between Indonesia and the Netherlands. So I'm taking over from Brechtje, who facilitated in organizing this, right? But Brechtje has finished her posting in Jakarta and she returned to the Netherlands. I came here, I've been longer in Jakarta, but I just returned from the Netherlands. I'm in quarantine now in a hotel in Jakarta. Yeah, but all day on video conference. It's at 3 o'clock.
Okay.
I have to be part of the cyber dialogue between Indonesia and so I can only be at the opening. But I wish you all the best for the webinar, and it's good to see you all. And good luck for this afternoon, this morning. Thank you.
Okay.
Thank you very much for attending.
Thank you very much, Rolf van der Erven, for warm welcome for this webinar. Thank you. Bapak Ibu peserta, ladies and gentlemen, participant of webinar online, we have two speakers here, and then we will followed by the last one, Honourable Justice Takdir Rahmadi will join. Okay, for the first, I would like to invite Professor Ian Smits to share with us about how important and how his experience in Maastricht teaching based on case law. Professor Ian Smits, time is yours.
Yeah, thank you so much. Also, thank you so much for the kind invitation and for the very warm welcome. I'm happy and excited to be back in Surabaya. Also with very happy memories of my visit to you a little more than 1 year ago. A lot happened in that year, and I hope that you are all in good health over there in Surabaya and in the other participating faculties in this wonderful project. I also salute my co-speakers, the Honourable Justice Professor Takdir Rahmadi, and of course Dean Iman Prihandono. And I'm very honored to be here. Now I'm going to try to share my slides. Yes, this should be visible now to everyone. Professor Awe asked me to speak about case law in the Dutch legal system. When I say case law, and the term is also here on the slide, I think you say jurisprudentie. That's very good because we say the same. As you know, we use the very same words in Dutch, so I'll also use the term jurisprudentie in my half hour that I have in this seminar. And I will try, in fact, to do 3 different things. I will try, first of all, to show a bit the importance of jurisprudentie in the Dutch legal system. As you know, Indonesia and the Netherlands share being a civil law system. So I will try to say a bit more about what in the Netherlands it means that jurisprudentie is part of that system. Second, I will try to say a bit more about why we teach, therefore, case law, jurisprudentie at Dutch universities in law schools. In fact, it is very important when you look at the curricula of Dutch law faculties. All our students get to know a lot about case law in every course that they have. I will say more about that later on. And then my third topic is indeed how to teach this case law. So what are practical ways of doing that? And what is the experience that we have with doing this here at Maastricht or at any other law faculty here in this country? My own field, and Radian was already very happy to point that out. My own field is private law, perhaps more in particular, indeed, contract law. So I will take a few examples from that field, but also some examples from other fields of the law. Now, let's start with the very first question. How important is jurisprudentie, in fact, in the Dutch legal system? Now, on this slide, you see a few photos. You see a photo of the seat of the Netherlands Supreme Court in The Hague. And you also see a photo of the, well, the main seat of the Council of State, the Raad van State, also in The Hague. These are, as I think you know, the two main, we have a few more for specific fields, but these are the two more, the two most important highest courts. The first one in criminal matters and in civil law matters and more in general. And the second one, the Council of State, the highest court in administrative matters. And I want to say a bit more about how these two courts indeed go about making very important case law within the Netherlands legal system. What you also see here is the main source of case law in a commercial edition, which is called the Nederlandse Jurisprudentie. Now, I had some conversation here with a colleague who actually comes from Indonesia, who did a little research into the main sources of law being recognized both in Indonesia and also in the Netherlands. And of course, perhaps of course, these are very similar. So when you look at the main Indonesian textbooks, or you look at the main Dutch textbooks, what you find there as being mentioned, as being recognized as sources of law are a few things. So we have, of course, statutes, legislation, but also we have jurisprudentie being mentioned there. Then in Indonesia, you have custom law. We also have the same source of law in the Netherlands, be it not of very great importance. We have international treaties. There we also have the same source in both countries. I would say in the Netherlands, I think that well, perhaps one of the most important treaties there, which is also very influential on the Dutch legal system, is the European Convention on Human Rights, which you do not have. You have other treaties also for international human rights. We have the same, but here the ECHR is in fact very important. And we have, well, often mentioned, if you look at these textbooks, also legal doctrine as a source, which is more disputed. Whether that's really an official source of law, I don't think it is, but it does play a role in the way in which practitioners go about finding the law, because they often tend to look at these, well, legal doctrine, at textbooks, for example, first, when they need to answer a specific legal question. And then, well, in the Netherlands, European law is also still luckily very important, which also does not play a role in the Indonesian legal system. But all in all, when you look at this little list, the first two sources, statutes and jurisprudentie, are no doubt in our two legal systems the two most important ones. Which is to say that law is made both by the legislature and by the judiciary, in particular by the Netherlands, by these two highest courts I just mentioned, the Hoge Raad, the Supreme Court, and the Council of State. So these are in fact seen as important lawmakers next to the Dutch legislature. And in fact, it is simply impossible to know Dutch law without also looking at the case law of these two judicial bodies. Now, I just want to give you a few examples of this important role of the courts to make it much more concrete. So what role do courts in fact play in the Netherlands in making the law? And I think what I say here is also really representative for many civil law jurisdictions elsewhere in Europe. Okay. So I have here tried to define three roles of courts, of the judiciary, in the making of Dutch law. There are still some more roles they can play in making law, but these are just, I think, three main examples. First of all, trying to interpret the law, including interpretation of statutes. And this may be very self-evident, but I will try to make clear why I find it important to mention this. Statutes always need to be applied to concrete cases. So we have here a very famous example from the field of criminal law. It's a very odd case, but I thought it nice to mention this case because it's exactly 100 years ago that it was decided. The so-called electricity case of the Dutch Hoge Raad. I also see Roel van der Veen laughing now because he may know this case when he studied. Yeah, right. When he studied apparently law, also at a Dutch university. We have here a provision of the Dutch criminal code, which is probably still also the same provision that you may have, at least when it comes to substance, which is about theft. So a person who removes any property belonging in whole or in part to somebody else with the object of unlawfully appropriating it is guilty of theft and liable to a term of imprisonment of no more than 4 years or a fine of the 4th category, it says in the full version of this article. Now, this was a case about a dentist who had this very nice electricity meter at his home, and who put a pin into the meter. You also see an example of such a meter here on the screen. So he put a pin into it, and then the meter stopped running. And he was prosecuted for theft of electricity. Now the question before the court was, you can imagine, was putting a pin into this meter also a case of taking away an object, taking away a goed, as we say in Dutch. So is electricity a good, and is putting a pin into it also a matter of taking away, of appropriating that good? That was the question before the Dutch Supreme Court, and the Supreme Court said yes, in view of the purpose of this very same article, which is, the Supreme Court said, to protect property, to protect value, protect property of this specific, of the electricity company. And electricity has, of course, value. Now, the reason why I'm mentioning this case is because I want to ask you in a way also the question, is this lawmaking according to you? Is this a case in which the law is made by, I have no doubt whatsoever that that is indeed the case, because it means, of course, that any other court in the 100 years after this decision was taken could point to this decision of the Dutch Hoge Raad and could say, well, yes, indeed, this is now the existing law in the Netherlands. And you may even say that through interpretation, the court here has been making the law and further developing the law. So in much more recent cases, just a few years ago, there was a very similar, not very similar, but a case also about this Article 310, where it was about a person who made use of the mobile phone of somebody else, used the phone of a friend, and started making calls and also started texting people with that phone. Is that also a case of theft? Well, there was a case also before one of the Dutch courts. And there too, the court said, yes, that's also theft, making use of somebody else's call credit or texting credit, because the property of that person is here also taken away from that person. And then very recently, another case, only last year, I think, it was about bandwidth. So using somebody else's internet. So looking into the internet connection of your neighbor, and then starting to well, browse and use the internet. Is that a case of theft under Article 310? There, in fact, it did not go all the way up to the Dutch Hoge Raad, but there the lower court said that it's not in this case, because this was not, well, a case in which the person who paid for the internet, so the subscriber, could no longer make use of it. So the fact that somebody else is also using your bandwidth means you can also still use it yourself. So there's no loss of value there, is what the lower court said. That's interesting. Perhaps there was some other criminal provision in the criminal code that had been violated, but it was not theft in that case. Okay, so this is interpretation of a statute, inevitable for any court to do. And I say this is also simply lawmaking. These decisions of higher courts tell also lower courts what to do, not because in a civil law system, these decisions of the higher court, like of the Hoge Raad, are formally binding. as in a common law jurisdiction may be the case under the doctrine of stare decisis, but simply because the lower court is eager to follow the case set by the, in this case, Hoge Raad. So you could say the higher case has persuasive authority. I will get back to that because it says something about the status of a civil law jurisdiction. Okay, that's one. Then second case, or second example of how courts are important in making the law is where courts fill gaps that you have in, well, in statutes. And very often these gaps are deliberate. When a legislature uses open-ended norms, left open to be filled in by the court, dependent on the circumstances of the case. And here we have, of course, a very famous example also. I only give famous examples in this seminar, and that's a case from civil law. And that's the famous article, in your case, 1365 of your Burgerlijk Wetboek. I know that you use the same term, the Indonesian Civil Code. We have a bit of a modernized version of that in our new Civil Code, but it's essentially the same provision, which is Article 162 of Book 6. And it's about tort. So it's about committing an unlawful act, as it says here, a case of tort liability. And what you find here, as you also have in your Article 3065, is indeed a very open-ended provision. That's now in our provision in Section 2, where it says that you can violate a rule of unwritten law pertaining to proper social conduct. Well, what is that? That needs to be filled in by the courts. And if courts do so, they often, particularly if the highest court does so, if the Hoge Raad does so, that's also a case of very much of lawmaking. So the Hoge Raad is giving hand and feet to this. And I could give you many examples, but time is always running too fast. So I will not be able to give you many examples. I just give you, well, let's start with one in any event and then see how far we get. This is a pub, a cafe in Amsterdam. And this may look a bit, I thought when I was in Surabaya a year ago, thanks to your great hospitality, I was taken to the cafe in Hotel Mahayapit. And I think, in fact, that it looks a bit like this in the let's say traditional style. In this cafe in Amsterdam, in fact, there was a visitor who came to this cafe and who fell in a cellar hatch. So a hatch that was open in the floor, and he fell in this cellar hatch when he was on his way to the toilets in the cafe. And the cellar hatch was open because there was this employee of the Coca-Cola company, the Dutch branch, Coca-Cola company, who was making deliveries to the cafe and who was taking Coca-Cola from his van outside to the cellar and was walking back and forth between his van and the cellar and leaving the hatch open. And then this guest to the cafe was injured because he fell into the cellar. He sued Coca-Cola, and the question was, were they liable for the injury of the guest? Now, we don't have the time to go into this in much detail, but here we find a very nice case of lawmaking by the court, because what the court did was that it really gave hand and feet, made very concrete, this open-ended provision that I just showed you in the provision on tort in the Dutch Civil Code, by mentioning a number of different factors that you need to take into account when deciding about liability of, in this case, the Coca-Cola company. Now this, to my mind, is really a case of very nice lawmaking by the Dutch Supreme Court. And the Hoge Raad, did not only decide the case in favor of the visitor of the cafe, but it also motivated this decision in, I think, a very nice way. By the way, these kinds of motivations that the court gives is something that the court is obliged to do. So in our statute on the judicial organization, it says that, of course, a court must motivate why it comes to its decision, so that the decision is also transparent and also helps other courts, lower courts, for example, to apply that case of the higher court to new cases. Yeah, so in a case like this is a matter of, so leaving open this tether hedge, it's what we call now in the Dutch legal system a case of creating danger, gevaarzetting, creating a danger for other people. And we have all kinds of cases about this in which, in fact, these tether hedge criteria from 1965 are being applied. We have some very nice cases, and just to give you one more there, this is a very nice, at least I liked, a very nice photo, at least I like it a lot. It's a photo of Maho Beach. Maho Beach is on the Dutch Antilles island of Sint Maarten, where, as you can see, well, the airport is very close to the beach. And we had here a very, well, perhaps also sad case about a tourist who was watching the planes touching down on the airport very close by. You see a few of these tourists also here on the beach. But what happened here was that one of these planes opened up its engine in order to, well, to in fact land on the airport, and was then thrown a few meters backwards onto the rocks that you also have there, and she was injured. She then claimed damages from the airport authorities for in fact creating another dangerous situation. So again, a case of gevaarzetting. And here too, the Dutch Hoge Raad applied those criteria that I just mentioned. And the question there was, in the end, because you may have seen it, I didn't mention it, but you may have read it for yourselves. One of the main criteria here is whether sufficient precautionary measures were taken to avoid liability, to avoid someone getting injured. And in fact, here the court said that just a warning sign that you can find on Maho Beach, this is the warning sign, was not enough to do that. So you need to do more than just put a warning sign there. So here too, there was in fact a case of liability of the airport authorities vis-a-vis this injured tourist. So what can you do more? Well, you can put a fence there, or an extra fence, or you can also, but it may be a very far-going measure, you can also close the beach in order to avoid anyone getting injured there. Okay, I'm not speaking too much about substance, but I do give you this example also to show you that, in fact, such a case of 1965 by the Dutch Hoge Raad is applied, well, every day. Well, every day more or less by the lower courts. Okay, then just one other and last example I will give you now as an example of lawmaking. Next to interpreting the law and filling gaps, courts also supplement the law by, for example, by deriving principles from existing rules. And then also applying those principles to future cases. And a very famous example of that is in the field of administrative law, where in fact the Council of State, the Raad van State that I already mentioned, developed, and also the Hoge Raad in fact, developed general principles of proper administration, the algemene beginselen van behoorlijk bestuur in Dutch. They are now laid down in the General Administrative Law Act, the Algemene Wet Bestuursrecht, but they were in fact developed by the courts and also developed by the courts. And there are many other examples of cases where courts supplement the existing law. For example, indeed by deriving principles from all kinds of well, dispersed fragmentary statutes that you can find. Okay, so these are just 3 examples of cases in which I would say, not the only one there, that courts are making the law. Now, what I understood was that there is some discussion in Indonesia about the question whether this is at all allowed in a civil law jurisdiction, that a court plays this role next to the legislature. Now, that's not really an issue in my country. What we tend to say in the Netherlands or in any other European civil law jurisdiction is that in civil law jurisdictions, there's always a very close interaction between the main legal actors. And the main legal actors here are the legislature and the judiciary, and also, in fact, academics who play a role here in the sense that they comment upon legislation and comment upon case law, jurisprudency, often leading to this case law or this legislation also being amended as a result of criticism by academics. So it's a bit of a triangle that you have there in civil law jurisdictions, where each of these players, legal actors, I like the word there, each of these legal actors plays its own role, where there can also be shifts in the sense, shifts in the sense that in some periods of time, the legislature may be more important, in other periods, the courts may take over. But that is, I think, essential in a civil law jurisdiction, that you have each of these three actors playing a role. Now, what I should add to this is that in a civil law jurisdiction, of course, the power given to the courts is also something that is there because the legislature allows this. So if the legislature would say, we don't agree with this court decision, then in principle, the democratic legislature can say, okay, we will make a statute that puts aside the court decision with a certain limit still, insofar as that does not violate the rule of law, like fundamental rights and some other fundamental principles. So we have seen something of this in the case of private law, with the new Dutch Civil Code, for example, entered into force, at least its main part entered into force in the early 1990s, where indeed the legislature introduced some provisions that went against previous court decisions. So that's also essential in a civil law jurisdiction. You may say that in the end, if the legislature wants this, it has the authority to put aside the court decision. But if it doesn't do so, then the decisions of the court are, I would even say, equally important often to decisions that the legislature has taken by way of statutes. And again, this is not stare decisis, as you may have in a common law jurisdiction, because the court case, the decision taken by the higher court, it's not that it must be followed in a lower case. There is no formal binding precedent. Each decision is only binding in the case itself, but when you look at practice, decisions of the higher courts do have a lot of authority. So they are very, very literally, you could say, leading cases. They also lead the lower courts to reach a certain decision in line with the decision of the higher court, and they are usually followed. Now, this is also possible because these decisions are published these days also on a very nice website, which is well entertained, organized by the Dutch judiciary itself, on which all the main decisions are published and in which everyone is able to look them up, and it also helps, of course, the predictability there. Okay, now that's my question one, and I will try to be much shorter when it comes to question number two, because I already gave the answer, I think. So question number two was, why should you want to teach jurisprudency? Well, I have simply two very straightforward reasons for this. First reason, it's impossible to know the law without also looking at the case law. And if students need to learn the law, they also therefore need to look at case law. Second reason, quite apart actually also from the first one, case law shows how statutes are used And I think that's also essential to training lawyers. So, statutes are well, often a bit abstract rules, but how do you apply them to real life cases? Well, case law shows how you can do that, how that is done in fact. And I think that's also very important for our students, that they are trained to apply those statutes to real life cases. And they have very nice examples in that by just looking at the way in which real courts do that. You can also make fictitious cases, as we also do in our courses, but it's often much nicer to look at how statutes are applied by real courts. Conclusion there for question 2 is, yes, we do need case law in teaching. And then I can immediately continue with my third question. So how to do this? How should you teach then this jurisprudency? Well, I put a few things here on the slide. I know that in this project you are also very much interested and try to apply problem-based learning. And for me, the essence of problem-based learning is that there is not, I like the expression a lot, not a so-called sage on the stage. So a wise man or woman who is standing before a very large group of students and who is telling these students how it is. No, problem-based learning is very much about allowing our students to, a bit abstract, to construct their own understanding of the materials, which requires them to actually work with these materials themselves. So they should really try to figure out, with the help, of course, of our teaching staff, figure out themselves well, what the case is actually about, or what the statute is actually about, what the law is actually about. And that requires an active participation. Now, how can you do that when it comes to learning jurisprudency? I think there are many ways. I just put one example here on the slide. What you can do, and that's something that we, I think, do in quite a few courses here in Maastricht, is that we try to assign tasks to our students. So, for example, when you have a case that has been published and it is available to everyone, what you can do is ask one student to present the facts of the case, another student to present the decision taken by the court, and the third student to present an alternative outcome to that very same case. And then you have, for example, presentations of each of these students for 5 minutes, and then you can have a nice discussion with the entire group about that. This is one way of doing this. What I understand is that there may be a difficulty, but we're going to hear about that more in a minute or so. And looking very much forward to that. What I understand is that there may be a difficulty of doing this in the Indonesian legal system, in the sense that the Indonesian courts often apply a set case template in which it's not always necessary to actually reason in a very elaborate way about the case, in the sense that the reasons for giving the decision may not be always very explicit. Well, if that's the case, we'll hear more about this, then what you can, of course, do is try to find similar cases abroad. So what you can try to do is to incite your students, motivate your students to find similar cases in English, for example, about similar fact patterns, and try to compare the Indonesian case with the foreign case. I think that may be a nice way forward in case you are uncertain about the exact reasoning that the court entertained when coming to its decision. But we can discuss this more later on in this seminar. This is just one example of, well, it's a very easy example, I think, of how I sometimes teach about a certain course in my course on comparative contract law. This is an English case, also a famous one, Liverpool City Council and Irwin. And then I do something that I just, along the lines I just mentioned. We ask the students to read the case. One student presents the case, the facts, the other student presents the decision taken by, in this case, still the House of Lords, the Supreme Court in the UK. And then we ask, okay, you can ask this for each of the different students that you have available. How would the French court deal with the case? How would the German court deal with the case? How would the Dutch court do this? And you'll get a really nice discussion about the arguments that you can use in a case like this. That's just an example, and we can discuss more examples in the discussion part of this seminar. Now, I've spoken for exactly 30 minutes, so that means that I will end this part. Thank you very much, and I look forward to the talk by our colleague and also to the discussion we're going to have.
Okay. Thank you, Professor Ian Smits, for a very interesting issue in your presentation. Jadi Bapak Ibu, kenapa harus belajar kasus? Karena impossible untuk memahami hukum tanpa belajar kasus. Karena apa? Karena pengadilan itu memerankan 3 hal penting. 1, interpretasi hukum. Lalu yang kedua, mengisi
Currently, Dr. Radian is wrapping up the presentation of Ian, Prof.
diatur oleh hukum. Lalu yang terakhir, menurut Profesor Ian Smits, pengadilan itu juga membangun prinsip-prinsip yang dihasilkan dari putusan, seperti di Netherlands tadi dicontohkan GALA, General Administrative Law-nya Belanda, itu juga dibangun prinsip-prinsip tentang.
Prof. John Smith stated that the principle of constructive court law is actually also facilitated by the principle of the statute.
Kita katakan belajar kasus itu adalah keniscayaan dalam studi hukum. Oke, thank you, Profesor Ian Smits. Kita akan bergeser pada next speaker. So now we already have Professor Takdir already joined, but I will give Honourable Justice Takdir the last person who will deliver his speech. Now I would like to invite Dean Iman Prihandono to deliver his presentation. Pak Iman, silahkan Pak Iman.
Currently speaking is Mr. Iman Prihandono, Ph.D. as the Dean of Law, University Airlangga.
Okay. Thank you very much, Radian. And also thank you very much, LL.M for organizing this very important event. I'm honored here to speak with Yang Mulia Profesor Takdir Rahmadi and also Professor Ian Smits, Dean of Maastricht Law School. Yang terhormat juga Pak Awe dan Dr. Sasha, lalu dari Kedutaan Besar Belanda. Kita juga ada kawan-kawan, kolega, dosen dari Sabang sampai Merauke yang telah hadir. I will present in bilingual, 2 language. My PowerPoint presentation will be in English, but I will speak in Bahasa Indonesia because most of the participants, I think, speaks Bahasa.
Yes, Pak Iman, you may full, Pak Iman.
Full, ya.
Full,
yeah. I will start with a brief history of case method. Case method pertama kali diperkenalkan 1870 di Harvard Law School oleh Pak Langdell. Sebelum 1870 itu
Case method is firstly introduced in the Harvard Law School in 1870 by the Christopher Columbus.
Dengan pada umumnya kita sekarang ya, lecture masih pakai textbook gitu. Tapi itu terjadi di 1870.
It is basically this similar what is applicable right now
dan membaca textbook
in our learning educations.
Peraturan perundang-undangan juga dari kasus-kasus. Tadi Profesor Smits sudah mengutip satu kasus yang hampir semua dari kita di PIH itu pernah mendengar, electricity case, atau hampir semua kita dari yang pernah belajar di Fakultas Hukum Indonesia ini putusan
with what Prof just stated, that all the cases have actually been studied and observed during the classes in our learning classes.
Tahu bahwa di electricity case itu dia taruh pin di meterannya gitu. Tadi diceritakan Prof Smits. Kita juga nggak pernah tahu bagaimana hakim sampai pada putusan Lindenbaum Cohen. Kita cuma tahu bahwa si Cohen mengambil data-data berkas-berkasnya konsumen dari Lindenbaum di mana dia pernah kerja.
However, there have not been any up to our knowledge that there are some legal facts that state in previous presentation by Prof. John Smith in our English class, legal class.
Sebenarnya adalah science, ilmu yang berisi prinsipal dan doktrin. Nah, buat Pak Lengdel, appellate opinion atau putusan Mahkamah Agung itu merupakan bahan dasar dari sains itu. Terus library adalah laboratorium dari anak-anak Fakultas Hukum. Jadi kalau saintis itu membuka tikus kan percobaan ya, tikus percobaan dipakai sebagai bahan percobaan, maka buat orang hukum, kata Pak Lengdel, untuk tahu bagaimana hukum itu bekerja, maka harus tahu dari kasus-kasus, dari putusan-putusan pengadilan, dalam hal ini appellate opinion, kata dia. Nah, sebagai science, maka seorang saintis harus mencari dari sumbernya langsung, original source. Nah, sumber langsung itu dari mana? Ya dari putusan pengadilan. Karena putusan pengadilan itu uncover katanya, menunjukkan, menjelentrehkan bagaimana fundamental rules dan principle of laws itu bekerja, gitu. Jadi itu sedikit sejarah mengenai kenapa atau bagaimana case method itu pertama kali lahir dan bagaimana dia lahir. Tujuannya apa? Tujuannya tadi Prof. Smits sudah memberikan sedikit gambaran mengenai tujuan dari apa yang bisa kita dapatkan dari case law, dari case method. Itu kalau buat Pak Lengdel, itu how lawyers think dan reasons. Karena mahasiswa bisa mencari fakta dari kasus, lalu dia mendapatkan legal question-nya, lalu bagaimana dia akan tahu bagaimana hakim memutuskan berdasarkan kasus-kasus sebelumnya dan peraturan perundang-undangan yang relevan terhadap legal question dalam kasus itu. Lalu bagaimana hakim melakukan discovery, membahas dan lain-lain untuk memecahkan legal question-nya, dan di putusan itu biasanya ada pertimbangan-pertimbangan lain dari hakim untuk memastikan bahwa apa yang dia capai nanti tidak akan memberikan keadilan, bukan sebaliknya, ketidakadilan gitu. Nah, di bagian akhir biasanya hakim memastikan sekali lagi bahwa aturan perundang-undangan dan prinsipal yang dipakai itu sudah sejalan dengan pemikiran hukum yang berjalan. Nah, yang kedua, dengan case law atau case method, mahasiswa jadi belajar bagaimana hukum itu di reform, dibuat ulang, atau tadi Hakim Pak Yan memberikan judge make law itu karena dia mereform aturan perundang-undangan yang sudah ada. Atau bagaimana sebaiknya tidak hanya mereform, tapi bagaimana reformasi itu, perubahan itu dilakukan. Jadi ada alasan-alasan yang dikemukakan oleh hakim, ada prinsip-prinsip, ada doktrin-doktrin. Lalu bagaimana hukum akan berkembang ke depannya. Kita tahu sekarang di Indonesia, hakim-hakim kita di Mahkamah Agung berpikiran ke depan. Ada banyak jurisprudensi yang memungkinkan untuk itu. Class action misalnya, dulu tidak, di putusannya pengadilan masih tidak boleh, tapi dalam perjalanannya pengadilan membolehkan class action. Jadi kita bisa memperkirakan ke depan kira-kira putusan-putusan ini akan seperti apa. Lalu apa prinsip-prinsip yang mendasarkan suatu aturan perundang-undangan atau hukum? Hukum itu didasarkan atas prinsip-prinsip apa saja. Beda dengan kalau belajar dari textbook, kalau belajar dari case law, case method, maka mahasiswa akan mendapatkan insight yang berbeda karena hakim membahasnya dalam putusan itu. Dan biasanya hakim juga merujuk pada putusan-putusan sebelumnya, jadi mahasiswa juga dapat belajar bagaimana putusan sebelumnya itu penting terhadap putusan yang sekarang. Nah, itu tujuan dari case method. Lalu ada keuntungannya, diantaranya studi dari Christensen bilang mahasiswa yang mampu untuk membaca kasus putusan secara efektif dan efisien itu akan lebih sukses dalam studinya daripada yang tidak, gitu. Jadi studi dari Christensen bilang kalau mahasiswa pintar atau pandai untuk membaca putusan-putusan, biasanya dia akan lebih sukses dalam studi di law school, dalam fakultas hukum. Yang kedua, membaca kasus dan belajar dari kasus itu membuat belajar hukum menjadi lebih menyenangkan. Lebih menyenangkan ya. Dibandingkan misalnya kita hanya belajar prinsip dan doktrin dari buku-buku. Karena kita nggak tahu bagaimana doktrin dan prinsip-prinsip itu bekerja. Hanya dengan kasus itulah kita jadi tahu bahwa bagaimana doktrin dan prinsip-prinsip itu hidup. Yang katanya the law comes to life melalui kasus-kasus. Lalu dalam metode kasus ini, case method, biasanya digunakan Socratic method juga. Jadi dosen bertanya kepada mahasiswanya, nanti mahasiswanya jawab, tapi pertanyaannya mendorong pada suatu jawaban yang benar gitu, yang diinginkan oleh si dosen. Ini membuat learning proses belajarnya jadi lebih terstruktur dibandingkan mahasiswa hanya membaca buku saja. Tapi sebenarnya ada beberapa tantangan dalam case method ini. Yaitu yang pertama, tidak semua mahasiswa tentu punya skill dan kemampuan untuk membaca kasus-kasus. Kita sejak tahun 2000, dimulai tahun 2000-an kira-kira, saya tidak tahu pastinya, jelasnya. Tahun 2000-an itu Mahkamah Agung sudah mulai merilis punya website di mana kita bisa mendownload putusan-putusan. Begitu juga dengan Mahkamah Konstitusi. Pada umumnya putusan-putusan pengadilan di Indonesia tidak sebanyak halamannya, ya, tidak sebanyak putusan pengadilan di common law system misalnya. Nah, tapi pada umumnya mahasiswa pun masih kesulitan untuk membaca putusan Mahkamah Konstitusi. Agak lebih panjang daripada putusan-putusan Mahkamah Agung. Agak kesulitan untuk dapat mengikuti alur berpikir dari para hakim. Karena biasanya bahasanya, biasanya juga putusan itu kan dibuat oleh orang hukum yang sudah terlatih, juga ditujukan untuk para pihak yang punya lawyer yang sudah terlatih. Dan tidak mudah bagi mahasiswa untuk, apalagi putusan-putusan yang dari luar negeri. Yang kedua, poor teaching method. Kalau dosennya juga tidak bisa mengajarkan case method secara baik, atau dosennya juga kurang memahami kasusnya misalnya, itu yang lebih parah lagi. Memang benar bahwa case method itu melatih skill analisa dari student, dari mahasiswa, tapi kadang dosen memanfaatkan ini untuk menunjukkan kepintarannya di depan mahasiswa, atau bahkan mengharas atau intimidate mahasiswanya, seolah-olah dialah yang paling benar gitu. Jadi akan lebih baik kalau dosennya juga pertama-tama harus mengerti kasusnya, membaca kasusnya lebih dulu, dan tidak bersikap menggurui, tapi memfasilitasi mahasiswanya untuk mencari tahap demi tahap, faktanya dulu apa, isunya apa, setelah isunya bagaimana hakim menyambungkan isu dengan rules, dengan statute, dengan putusan sebelumnya, terus bagaimana hakim mencapai putusannya. Begitu terus sampai prinsip dan doktrin diterapkan dan lain-lain. Jadi bukan benar dan salah, bukan benar dan salah, bukan membenarkan, tapi bukan juga menyalahkan. Yang ketiga, dalam belajar hukum tentu tidak hanya membuat mahasiswa kita untuk pandai menjadi think like a lawyers, sebagaimana yang diinginkan Langdal, tapi mahasiswa kita juga tentu perlu skill yang lain. Skill yang lain. Nah, skill yang lain itu kata Marjorie ada paling nggak 26. Nah, coba Bapak Ibu yang dosen, kita lihat sama-sama 26 skill ini apakah sudah kita pastikan ada dalam mendidik mahasiswa-mahasiswa hukum kita. 18 misalnya stress management. Itu juga harus ada, karena sebagai lawyers, sebagai juris, apapun dia, hakim, jaksa, pengacara, tentu pekerjaannya akan banyak, dan mereka tentu harus tahu bagaimana stress management itu. Nah, sebagai penutup, saya mau memberikan beberapa challenge, beberapa tantangan bagaimana case method ini diajarkan di Fakultas Hukum di Indonesia. Pada umumnya kan kira-kira sama dengan apa yang disampaikan oleh Pak Jan Smits, cuma kita punya beberapa tantangan spesifik yang masih ada di Indonesia. Misalnya legal tradition dan the way lawyers think. Biasanya lawyer-lawyer kita tidak konsisten. Kalau kasusnya itu menguntungkan bagi dia, maka jurisprudensinya dipakai. Jurisprudensinya tidak menguntungkan, maka argumentasi dia biasanya bilang, meskipun ada putusan sebelumnya, tapi kita tidak terikat stare decisis, begitu. Agak susah, ya. Atau legal tradition dalam mengajar, seperti kasus Lindenbaum-Cohen dan kasus electricity, biasanya dosen-dosen di kelas masih hanya memberi kasus itu sekilas, hasilnya aja, putusan akhirnya seperti apa. Tapi bagaimana ceritanya, bagaimana hakim sampai pada putusan itu tidak pernah dibahas di kelas, hasil akhirnya. Dan itu bukan case method. Case method tidak begitu, tidak mengutamakan hasil akhir dari kasus. Lalu ketersediaan dan akses terhadap kasus-kasus, memang benar sekarang kita bisa mengakses putusan Mahkamah Agung dan Mahkamah Konstitusi, tapi tentu tidak hanya itu yang dibutuhkan oleh mahasiswa, dibutuhkan juga akses kepada putusan-putusan misalnya di luar negeri, di Belanda, di Australia, di Singapura, dan lain-lain dalam melakukan risetnya. Teaching method dan kemampuan dari dosen untuk memberikan case method juga belum tentu sama. Sekarang memang ada banyak lulusan-lulusan dosen-dosen, lulusan-lulusan luar negeri yang mulai menggunakan case method. Tapi pada umumnya karena keterbatasan waktu dan silabus yang tidak memungkinkan sehingga case method belum banyak digunakan. Yang selanjutnya adalah kemampuan membaca, menganalisa, dan mengekstrak opinion dari hakim. Ini yang skill ini yang perlu kita berikan kepada mahasiswa sejak semester 1, yaitu karena di SMA kita biasanya mahasiswa baru anak-anak SMA kita tidak belum di-encourage untuk membaca. Misalnya harus membaca dan menulis. Sehingga waktu dia masuk ke universitas, kemampuan membaca dan menulisnya agak kurang baik. Yang selanjutnya adalah tantangan bahasa untuk melihat atau membaca putusan-putusan asing dalam bahasa Inggris misalnya, atau bahasa Belanda, bahasa Prancis, dan lain-lain. Tantangan berikutnya tentu ada student work-life balance yang perlu kita pertimbangkan. Memang di Indonesia kasus-kasus itu tidak setebal putusan-putusan di luar negeri, tapi tentu dosen harus juga mempertimbangkan kasus-kasus yang relevan dan yang penting, yang landmark untuk dibaca dan dianalisa oleh mahasiswa. Bukan semua kasus atau kasus bahkan yang tidak terlalu relevan disuruh baca juga, karena tentu mahasiswa juga punya extracurricular activities dan family social life activities lainnya. Rasanya itu, Pak Radian. Terima kasih. Nanti kita lanjutkan di tanya jawab, misalnya masih ada waktu.
Terima kasih Pak Iman. Saya kira sangat precise dalam menampilkan tantangan di dalam implementasi atau di dalam menggunakan case untuk studi-studi hukum. Jadi apa yang disampaikan oleh Pak Iman itu di pada bagian akhir semacam agenda apa yang harus kita lakukan di pendidikan hukum di Indonesia untuk lebih baik dalam soal case law, ya. So I think from last point of Pak Iman presentation is kind of program or strategy how to implement case law method in legal education in Indonesia. For example, Pak Iman already identify one of the difficulties is how to read a decision of the court. Yeah, I think there is no specific topic in law school about how to read a court decision. Yeah? Oke, terima kasih Pak Iman atas presentasinya. Telah bergabung dengan kita Profesor Takdir Rahmadi. Profesor Takdir Rahmadi is Justice of Mahkamah Agung. Pak Takdir ini expert in environmental law karena S3 beliau, doktoral programnya dari Faculty of Law Airlangga di bidang hukum lingkungan. Ya. Saya kira saya juga skripsi hukum lingkungan dulu S1, saya juga merefer bukunya Pak Takdir waktu itu. Ya. Profesor Takdir appointed as Justice of Supreme Court on 2008. And he got professorship from Universitas Andalas Faculty of Law. Okay, Professor Takdir, he will present his text in Bahasa Indonesia, but I think he will deliver his speech in English. Profesor Takdir Rahmadi, dipersilahkan.
Oke. Assalamualaikum warahmatullahi wabarakatuh. Selamat sore. Kedengaran Pak Salman?
Ya, jelas Takdir.
Okay, thank you. So, good afternoon to our guest lecturer, the participant from Netherlands. I'm sorry, I will also have to speak in Bahasa Indonesia because I heard from the host from the Faculty of Law, Airlangga University.
Yes.
They provide interpreter for the Dutch participant. So I would rather
Please, yeah.
Representation in Bahasa Indonesia as well as my PowerPoints are also in Bahasa Indonesia. And Bapak Ibu yang terhormat, terutama Fakultas Hukum Airlangga, Universitas Airlangga, Bapak Dekan, saya mengucapkan terima kasih karena saya sudah diundang. Juga panitia lain, mungkin kalau ada kerjasama dengan lembaga lain, terima kasih sudah mengundang saya. Saya merasa terhormat karena diundang dalam forum akademik yang sudah lama saya tidak hadiri, ya. Meskipun secara Zoom online karena pandemik. So, and mungkin juga maaf karena saya baru mengalami surgery, sound surgery, jadi operasi lidah karena saya dapat tumor lidah. Jadi pengucapan saya mungkin nggak begitu jelas ya, mohon maaf. So my pronunciation is not really clear because I have a problem with my tongue after tongue surgery last year, yeah, at the end of 2020. Jadi I will start. Ya. Saya akan mulai dengan asumsi-asumsi yang mendasari pendidikan Indonesia. Nah, tadi sudah banyak disinggung oleh dua pembicara sebelumnya, bahwa Indonesia adalah bahagian atau rumpun dalam sistem Eropa kontinental, civil law. Nah, Eropa kontinental itu sumber hukum utamanya adalah perundang-undangan, statutory regime. Oleh karena itu, fokus pembelajaran paling tidak di masa saya, mohon maaf kalau saya salah, tapi jadi diadakannya acara hari ini dengan tema pembelajaran berbasis kasus menandakan bahwa proses pembelajaran atau edukasi atau proses perkuliahan di Fakultas Hukum Indonesia umumnya berbasis peraturan perundang-undangan saja dan pandangan atau uraian-uraian dari para ahli hukum, dosenkah, para praksisikah yang menguraikan saja, ya, tapi tidak membahas atau sekurang-kurangnya tidak menganggap penting untuk mempelajari putusan-putusan hakim. So in my view, and I think also most of us may agree that legal education in Indonesia focus only on statutory regime and pay less attention to review case law. Why? Nah, alasannya mengapa? Ya, kurang fokus pada case law atau studi kasus perkara. Next, tolong paparan berikutnya. Tolong Pak Salman. Ya. Mengapa ada misperception? Why? Ya. Karena tadi menganggap karena Indonesia adalah sistem civil law part of the continental Europe, enggak mementingkan, ya. Does not see case law as important for law students, ya. Jadi enggak penting mempelajari case law atau putusan-putusan hakim. Kemudian juga rata-rata buku-buku, termasuk buku saya sendiri mungkin, baru belakangan saya sadari, saya tambah beberapa kasus, kurang mengulas putusan-putusan hakim, ya, kurang membahas putusan-putusan hakim. Juga dunia bisnis, khusus publisher, para penerbit di Indonesia, itu tidak tertarik menerbitkan buku-buku yang membahas putusan-putusan pengadilan dengan memanfaatkan tenaga dosen, meng-hire dosen untuk membahas putusan. Misalnya, ya, buku tentang kasus lingkungan, dosennya dibayar oleh publisher, nggak ada itu. Ya, kalau di Belanda itu seperti itu. Di Amerika seperti itu. Jadi antara akademisi dan publisher sudah ada pemahaman yang sama. Jadi sudah ada yang membahas kontrak, perjanjian, PMH, perbuatan melawan hukum, tipikor, ya misalnya, semua sudah ada. Di samping itu di masa lalu pengadilan sendiri tidak mempublikasikan putusan-putusannya. Jadi ada problem with the access to case law, to case court decision. Ada problem. Next, berikutnya. Nah, oleh sebab itu ada kritik dari Presiden Hofrat dan Profesor Adrian Bettner dari VVA, dari Van Vollenhoven Institute, Leiden University. Tanggal 5 Desember, ini tahunnya kurang, 5 Desember 2018. Di Fakultas Hukum UI ada diskusi dengan tema The Use of Case Law in Legal Education dengan pembicara Martin Vetris dan Profesor Adrian Bettner, terutama Pak Bettner, dan juga ada satu lawyer, Gustav Ring dari Belanda juga. Dari pengamatan mereka, pendidikan hukum Indonesia itu tidak atau kurang memfokuskan kepada pembelajaran case law perkara, ya, karena menganggap karena kita sistem Eropa kontinental tidak penting case law, ya. Nah, mereka menyarankan mahasiswa hukum perlu memahami tidak saja hukum dalam arti abstrak, law in abstract sense, tapi juga law in concrete sense. Pengertian concrete sense adalah hukum yang diterapkan oleh hakim. Hukum baru bermakna apabila diterapkan. Salah satu penerapannya adalah melalui pengadilan. Dan di Indonesia sering juga terjadi perbedaan Yang di Belanda setahu saya tidak begitu lagi. Kalau kita studi program magister atau doktor dalam seminar-seminar dalam ujian disertasi, para pengujinya pun juga berdebat, ya, antara pendekatan normatif dengan empirik. Nah, ini juga akibat dari pemahaman kita yang selalu saja membedakan. Maaf, sudah mulai suara saya. Antara normatif dan empiris. Di mana di Belanda tidak begitu tajam. Ya. Dan di Belanda juga ada sinergi antara dunia peradilan, akademisi, dan publisher, penerbit. Pengadilan memanfaatkan hasil kerja dosen, publikasi dari para penerbit. Nah, di Indonesia belum terwujud. Belum ada. Ya, kalau di sana hakim untuk melihat jurisprudensi, saya minum. Ya, nanti. Bapak Ibu, karena operasi itu tenggorokan saya mudah kering, jadi sering batuk saya. Kalau banyak bicara ya batuk. Oleh sebab itu sekarang saya nggak bisa ngajar lagi. Jadi belum ada sinergitas, belum ada koordinasi. Next. Nah, tapi akhir-akhir ini, in the last few years, let's say maybe 5 or 10 years, Mahkamah Agung telah menerapkan transparansi policy. Putusan pengadilan tingkat pertama, tingkat banding, dipublish melalui namanya SIPP, Case Tracking System. Kemudian ada info perkara, so crisis information. Ini bisa digunakan untuk menelusuri perkembangan perkara pada Mahkamah Agung. Siapa hakimnya, sampai di mana prosesnya, masih dibaca, sudah putus, putusan sudah disampaikan kepada pihak, bisa dilihat perkembangan case pada tiap tahap. Kemudian yang ketiga adalah directory putusan. So, court decision directory. Ini memuat putusan-putusan lengkap. Kasasi maupun PK, penilaian kembali. Caranya, next, Bapak, ya, Bapak Ibu, ya. Caranya dengan bisa mengklik nomor perkara atau para pihaknya, maka akan keluar. Ya, ini contoh dari direktori putusan. Jadi akademisi, mahasiswa bisa memanfaatkan ini. Kalau di Belanda ini adalah bagian dari bisnis. Penerbit menghasilkan analisa putusan-putusan dari hakim yang dilakukan oleh para dosen, kemudian dipublish. Kemudian hakim memanfaatkan seperti itu, ya, untuk melihat putusan-putusan yang sama. Berikutnya, ya, ini informasi perkara, nomor perkara, jenis, ya, pengadilan asal, tinggal mencari. Next, saya sudah hampir habis ya. Kemudian juga Mahkamah Agung sudah memberikan himpunan jurisprudensi edisi pertama. Baik hard copy, this is hard copy, maupun di dalam website Mahkamah Agung. Ada feature, there's feature of correction of jurisprudency, the first edition. Second edition will be published, maybe this year, at the end of this year, maybe. Kebetulan saya chairman of the working group. Ya. Nah, kita akan berusaha Mahkamah Agung tiap tahun menerbitkan jurisprudensi, kumpulan jurisprudensi. Jadi beberapa, misalnya satu topik, misalnya perdata tentang pembeli bertikat baik. Ya. Ini apa aja putusan yang sudah mendukungnya, yang mengikutinya. Ya, putusan asal dan putusan berikutnya. Kemudian Mahkamah Agung juga sudah mempublikasikan melalui laporan tahunan landmark decision. Di dalam annual report itu sudah ada. Juga di dalam website sudah ada. Namanya putusan yang terpilih. Putusan terpilih. Ya, tidak pakai bahasa Inggris tapi terpilih. Saya kira terakhir ini contoh dari isi putusan. Nah, kita lihat ada kepala putusan, the head of the verdict or decision. Memang ini perdata ya, the identity of parties. Kemudian positanya, gugatan para pihak, dalil dari penggugat, baru jawaban respon dari defendant atau jawaban tergugat, uraian alat bukti, dan yang penting tentunya akan dipelajari oleh mahasiswa adalah pertimbangan hakim, judgment dari hakim. Terakhir ada amal putusan. Nah, itu yang harus tentunya dipelajari seperti kata Pak Dekan tadi. Saya kira saya sudah mengakhiri presentasi saya. Terima kasih.
Baik, terima kasih Prof. Takdir. Thank you very much, Professor Takdir Rahmadi, for presentation. Before question and answer, I would like to give a summary for presentation from Professor Takdir. Professor Takdir start with a wrong assumption on legal education or misperception concerning legal education on the basis of legal system. So in Indonesia, in his view, we still have a view on that it is not so important to study about decision of the court because we are civil law, then prefer to study on statute or legislation. And he thinks that it is a wrong assumption. Second part of his presentation is that in the context of Supreme Court, the Supreme Court already changed in terms of policy on openness. So we can now easily find decision of the court from the lower court until Supreme Court in the website of Mahkamah Agung, in the website of the Supreme Court. And he also explained that every year Mahkamah Agung, Supreme Court, publish jurisprudency and also publish some landmark decision on the case of civil law, civil case, administrative case, and etc. So I think that is a main point from Professor Takdir Rahmadi. Now we have time for question and answer about 30 minutes, and you may raise your hand or you may write your question in the chat. So Bapak Ibu bisa menggunakan chat atau Bapak Ibu bisa langsung raise hand untuk menyampaikan sesuatu kepada para speaker di forum ini, ya. I see, saya lihat ada Pak Gregorius yang sudah raise hand. Sebentar Pak Gregorius. And I have to see other, okay, wait. And also Bu Retno. Oke, Pak Gregorius, dipersilahkan, please.
Okay,
yes, please.
Thank you very much, Pak Radian Salman, as a moderator for the discussion for this evening. Good evening, all the speakers. Yeah, I would like to ask about the basic or the fundamental thing relating the model of the studying in Faculty of Law, particularly in modern era. Yeah, nowadays, yeah, it is really different. Yeah, with the traditional method in civil law or in common law. Yeah, based on my observation, I think nowadays we cannot to deny, yeah, to mix the model between the common law and civil law. It is mean even it is in the civil law, yeah, we also must to explain and using the model of case law, yeah, for the student in Indonesia particularly. I need the comment from the speaker. And the second thing, based on the tradition of common law, yeah, I think also nowadays, yeah, when we try to explore about the case law, we also must link it, yeah, with the model of the civil law tradition. Yeah, we also must explore the doctrine, the statute, etc. Because it is very important, yeah, to understand the ratio decidendi and obiter dicta of the way of thinking of the judge in district court, in appeal court, and also in the Supreme Court. I need a comment from the speaker. Thank you very much, Pak Salman. Pak Radian Salman.
Pak Gregorius, terima kasih. Now, Bu Retno, please unmute your microphone, then please, you may speak. Ibu Retno, you raise hand. Okay, Bu Retno still, I don't know, somewhere. Saya persilakan, ada lagi Bapak Ibu. Here in chat, in bahasa, is it possible to mix when we teach in Indonesia, to mix between two systems, civil law and common law in our teaching? I think similar to question from Pak Gregorius. Oke, Bapak Ibu masih ada lagi ada yang ingin memberi komentar atau pertanyaan, please?
Yes, Maya.
Bu Maya, okay, please, Bu Maya, and then we give to the speaker to respond. Please, Bu Maya.
Okay, thank you, Mr. Radian. Okay. I want to know about case method. I think this is first for faculty, law faculty in my country. Ya, oleh sebab itu saya ingin, in Indonesia, it is quite difficult for a student to read a court decision to adjust his thought to what is implied in the thought of the judge. As in theory, Columbus Langdale, in the method, the case is related to analyze to describe, to mempertahankan our student analyze about the session scores. How now I want to asking Mr. Yasmit why we can do for the student to try to make the case method for the next time in online study. Thank you.
Okay. Okay. Professor Yanspi, the question from Bumaya is how to implement case method in online learning since we are now in time of pandemic. Okay, I would like to invite first Professor Yanspi, but before Professor Yanspi respond question from participant, it is free for you also to have response speech from other speakers. Yeah. Okay. First, I would like to invite Professor Jan Smith to give response, please.
Yes, thank you very much, Radian, and also thank you very much to the two distinguished previous speakers. I very much enjoyed your two talks, very insightful. When it comes to the questions, perhaps I can indeed try to start with the question that was raised by both Gregorius and Maya.
Yeah.
I think the two questions are a bit related because it's about, let's say, how to apply the case method, partly also in online teaching, but I will say a bit more about that later. And how can you do that when you may not entirely know the ratio decidendi of the decision that was taken? At least that's what I also got from the question by Gregorius. Perhaps first about this point of the ratio decidendi. I already said in my talk that, and I would be interested in hearing from you about this actually. I said in my talk that there is a certain format that is used by the courts in Indonesia, and that this format may not always stimulate a court to give the ratio decidendi for the decision that it is taking. And I would like to hear from you actually how that works and how you can incorporate cases decided upon by the Indonesian courts in your teaching, even though that ratio decidendi, so the reasoning of the court, may not be there in the case itself. That's also a question that I give back to you for this discussion that we are having now. Like I said, if the ratio decidendi is not there, what you indeed can try to do is to look at similar cases where you do find the with cases with similar fact patterns, so to say. For example, but it does require some language requirements there from your students. For example, cases that were decided in English or in other languages where possible. Now, how to apply the case method? I think that's the question that was put before us by Maya. Perhaps first, one point of clarification. I very much enjoyed the talk by Dean Prihandono. What I would like to make clear there is that what I spoke about when I spoke about cases is not the case method in the, let's say, Langdellian Harvard way. So the American case method is different from the way in which we deal with cases in our teaching at Maastricht or in a civil law case. Because like I said, what we very much try to do there is to show the cooperation that there is between the different legal actors, in the sense that they make the law together. So legislatures are still very important. The judiciary, the courts are still very important. There may also be other legal actors like academics, and the way in which the law is made. And I think it's nice to show that to your students. The way in which the law is made is often in this, cooperation between those three actors. So when we speak about the American case method, what is being done there is indeed that students learn the law by reasoning based on the cases. that may be difficult if there is no reasoning that is made explicit in the Indonesian court cases. So then you cannot really use the case method, I would say. Now, the question that was also put by Maya is about online learning. That's a very important question, in particular in times of COVID-19. I don't think it makes too much of a difference in the sense that, or perhaps it's even in a way easier, because what you can do in online teaching also is to ask your students, when you have, let's say, a 2-hour time frame in which you have those students available. What you can do, of course, is to ask your students to split up in some small groups. For example, in this Zoom system, you have breakout rooms, and ask those students with, let's say, 3 or 4 students together to discuss a case, and then come back to the main session later on and ask the students what they have found. And that may be even easier to organize in an online setting than in a setting in which you have all the students before you in class, because then they may have to go to other rooms, or anyway, you can very easily organize that in a Zoom meeting. So perhaps doing this online may even help to have more of an interaction between the students and to have discussion among the students themselves, getting back to the main group and to the professor later on.
Okay, thank you, Professor Jan Smits. Now, Pak Iman, you may respond question from Pak Gregorius and Bu Maya, please. And I would like to remind our speakers that in chat there are some questions. Please, you may take that question relevant for your topic. Okay, Pak Iman, please.
Ya. Terima kasih Pak Gregorius. Pak Gregorius ini Rektor Universitas Atmajaya Yogyakarta 2015-2019, kawan dekat. Kita sama-sama di hukum internasional. Jadi tapi mohon maaf kalau pertanyaannya saya kurang jelas Pak Gregorius, tapi kira-kira sama dengan pertanyaan yang lainnya, yaitu is it possible to mix two systems, civil law and common law, dalam pembelajaran di pada prakteknya dalam legal education yang sekarang kita di Indonesia sekarang ini, civil law system dan common law system sudah sangat tipis untuk dilawankan, dikotomikan satu sama lain, karena kita belajar sekarang ini dua-duanya di Indonesia ini. Kita belajar dari civil law system di Belanda, di Perancis, di Jerman. Begitu juga banyak sekarang dosen-dosen baru kita, dosen-dosen muda yang baru pulang dari universitas-universitas di common law system di Australia, di Amerika, di Inggris, dan lain-lain. Itu mempengaruhi bagaimana pendidikan hukum kita ke depan. Nah, case method sebenarnya bisa diaplikasikan di dua-dua sistem hukum ini, nggak ada masalah. Masalahnya mungkin hanya pendekatannya aja yang berbeda. Karena di civil law system, tadi Pak Dean Jan Smits sudah bilang, legislation, statute itu masih penting untuk dipertimbangkan. Sedangkan di kawan-kawan kita yang studinya dari common law system, biasanya nih di kelas sering merujuk kepada case law lebih utama. Tapi buat kita yang di hukum internasional, ya Pak Gregorius, case law itu sudah nggak asing lagi di hukum perdagangan internasional, apalagi di WTO decision. Bagaimana kita menjelaskan like product misalnya, mau nggak mau harus merujuk pada decision dari WTO, karena mereka yang menginterpret, hakim-hakim appellate body yang menginterpret like product. Begitu juga dengan ICJ decision. Sejak awal kita mengajarkan hukum internasional di sumber-sumber hukum internasional, pasti pakai ICJ decision. Nggak mungkin tidak. Nah, itu satu contoh di mana case law sebenarnya sudah diajarkan sejak awal di Fakultas Hukum kita. Tantangannya mungkin sebenarnya bukan dikotomi antara civil law dan common law, tapi tantangannya itu tadi availability dan accessibility dari putusan. Tantangan kedua, Profesor Ian Smits tadi sudah bilang juga, tidak semua putusan itu bagus. Bisa jadi ada putusan hakim yang tidak sama sekali merujuk pada doktrin, pada prinsip, tapi langsung jumping to conclusion bahwa iya dia salah, ya ini masuk unsur dalam pasal tertentu. Itu yang masih agak sering susah kita cerna sebagai pengajar ya, sebagai pengajar. Ini putusan kok nggak ada rasio desidendinya sama sekali. Isinya hanya cerita aja, hanya cerita seperti di novel. Itu yang susah. Itu accessibility, availability, terus beberapa putusan memang tidak bisa dipakai, dan kemampuan dari membaca, menganalisa dari mahasiswa. Juga dosen-dosennya tentu. Dosennya perlu dilatih lagi untuk mengajarkan case law ini, karena tidak mudah untuk mengajar dengan case method. Ada banyak cara tadi, diantaranya mungkin pendekatan Langdalian kalau mau dipakai, pendekatannya Amerika, atau menggunakan pendekatan seperti yang digunakan oleh kawan-kawan kita yang di civil law system di Belanda misalnya. Nah, kita sendiri belum ada tradisi itu masalahnya di Indonesia ini. Tradisi itu belum ada. Kita mau bagaimana? Sehingga banyak dipengaruhi oleh si dosen itu sendiri. Kalau dia lulusan dari Belanda, tentu dia di training, mempunyai experience dengan metode model Belanda gitu, atau Jerman atau Prancis. Kalau dia lulusan dari dari common law system, mereka di training dengan metode civil law system, jadi mereka di kelas juga lebih mempengaruhi bagaimana mereka mengajarkan. Gitu rasanya dari saya. Terima kasih Pak Radian.
Okay, thank you Pak Iman. Before Pak Professor Takdir, I would like to resume main point from Dean Iman. In the perspective of Dean Iman, it is not relevant to strictly make a dichotomy between civil law and common law in terms of legal education. So we can apply case law in both system. Which one we use, Langdalian or method used commonly in civil law, we can use both. But Pak Iman, interesting point from Pak Iman is in Indonesia we still don't have a, let's say, a tradition or choice which one is correct. He means that sometimes because a lecturer graduate from Australia, graduate from America, then he used a method when he learned from university from Australia and America. But when a lecturer graduate from Netherlands, then he usually use a method as a Professor Ian Smits said. So it is necessary to sit together to determine how to teach a case in law school. Yeah, that is a main point from Pak Iman. Pak Takdir, ada respon? Saya persilahkan Pak Takdir.
Baik, terima kasih Bapak Moderator. Jadi dari pertanyaan yang muncul, baik dari secara oral maupun melalui chat, masih ada misperception. Misalnya di sini saya baca. why case law? Ya, why not civil law? Kita sudah. Mengapa harus pakai case law? Itu kan mempertentangkan antara case law dan civil law. Seolah-olah civil law itu nggak boleh menggunakan case law. Itu yang keliru. Ya, bahwa ahli hukum Belanda seperti Profesor Jan Smits, Ketua Mahkamah Agung Belanda, Prof. Vitris, ya, Martin Vitris, maupun Profesor Radian sudah mengingatkan bahwa di Belanda yang merupakan juga adalah keluarga dari rumpun civil law Eropa kontinental, mereka mempelajari, Fakultas Hukumnya mempelajari putusan-putusan hakim. Nah, oleh sebab itu kalau di Indonesia, ya, yang sudah dimulai dengan mengundang para dekan tanggal 5 Desember 2018. Jangan hanya menggunakan pasal demi pasal, uraian-uraian. Tapi bagaimana penerapan pasal itu oleh hakim? Apakah itu nanti penerapannya jelek, putusan jelek? Itu yang diulas. Oleh sebab itu untuk mengubah, jangan buru-buru ke mahasiswa. Dosennya dulu berubah cara berpikirnya. Bapak Ibu yang saya muliakan para dosen berubah dulu. Way of thinking, view-nya, mindset-nya. Jangan dipertentangkan dari pertanyaan kelihatan. Why should we study case law? Why should not study civil law? Case law itu ada juga di civil law. Nah, oleh sebab itu, Bapak Ibu dosen riset penelitian putusan-putusan hakim. Jangan buru-buru mahasiswa suruh belajar langsung ke putusan hakim. Ya puyeng, pusing. Betul kata Ibu tadi. Bapak Ibu menyajikan dalam bentuk buku. Ini pertimbangannya. Pertimbangannya misalnya apa ya? Bisa dinilai apakah konsisten dengan putusan lain. Nah, bisa mengkritik sekaligus sumbangan kepada pengadilan, kepada hakim. Nah, kami sudah ada di sini membimbing para hakim. Mungkin saja ada hakim yang nyeleneh, boleh menyimpang dari jurisprudensi, tapi harus ada penjelasan. Misalnya di sini dalam perdata pembeli bertingkat baik harus dilindungi. Nah, apa ciri pembeli bertingkat baik? Membeli dari orang yang namanya tercantum dalam sertifikat. Membelinya melalui AJB-nya, akta jual beli dalam PPAT. Sebelum jual beli tidak ada perkara. Objek jual beli tanah tidak sedang digugat, tidak sedang disita. Kalaupun belakangan diketahui setelah jual beli terjadi, ternyata si penjual bukan pihak yang berhak, maka pembeli bertingkat baik harus dilindungi. Pemilik asal hanya bisa membuat ganti rugi kepada penjual yang tidak berhak. Tanah tidak bisa kembali. Nah, jadi Bapak Ibu bisa survei, riset. Bagaimana hakim memahami pembeli bertingkat baik. Bisa saja memberikan kritik. Jadi jangan buru-buru mahasiswa ditugaskan. Bapak Ibu menulis dulu. Misalnya di sini sudah ada dalam rangka HAM. Ya, hak waris perempuan laki-laki adalah sama. Sementara dalam hukum adat di beberapa suku Indonesia, perempuan nggak dapat sama sekali hak waris itu. Sudah ada jurisprudensi menyatakan anak perempuan pun dapat. Sudah ada di sini. Ya, waris adat. Seperti ini. Ada nomor-nomor putusan. Nah, andai kata dalam penelitian Bapak Ibu ditemukan ada pula putusan yang menyimpang tanpa alasan yang jelas, bisa diberi kritik. Ada kritik. Bisa jadi umpan balik bagi Mahkamah Agung, ternyata kesatuan hukum, legal uniformity, legal certainty belum ada. Karena hakimnya masih kesana kemari putusannya. Hukum yang baik seperti di Belanda juga haruslah mencerminkan legal uniformity. Ya, tempat kejadian bisa beda, bisa di Surabaya, bisa Jakarta, bisa di Medan. Tapi question of law, apakah pembeli bersertifikat baik di negeri atau tidak, harus sama. Ya, itulah hukum. Tapi kalau di PN Surabaya, lain pula putusan Mahkamah Agungnya. Di Jakarta, lain pula. Di Medan lain pula. Pada masalahnya sama. Ya. Misalnya ada hakim agung, oh perempuan nggak dapat hak waris. Wah, dia berarti mengingkari jurisprudensi. Itu kritik diungkap publik. Berarti Mahkamah Agung gagal membangun legal uniformity. Fail to build legal uniformity. Mulailah dari diri dosen. Publikasikan. Dekan bisa menjalin kerjasama dengan penerbit. Hire dosen, ya kan, walaupun honornya kecil saya tahu. Tapi tulis, jadi jangan hanya menggunakan pasal-pasal. Tipikal, misalnya. Uraikan, ada nggak disparitas, misalnya. Seperti itu, jadi mulai dari dosen. Survei putusan, bahas putusan. Jadi jangan mahasiswa dulu. Kalau mahasiswa dulu memang nggak paham dia. Dimulai dari kita. Demikian Pak, makasih.
Thank you, Pak Takdir. I would like to summary from main point from Pak Takdir. Very interesting for us as a academia. Pak Takdir said that do not push your students to study case law. Yeah? He means that do not push, that start from the lecturer. Yeah? Lecturer must read and also conducting research based on case law. Yeah, so it is difficult for students to read a decision. So it must be started from lecturer. That's first point. So first point from Pak Takdir push us as a lecturer, as academia to study based on case law and also publish research or analysis based on decision of the court. Second, challenge from reading and research based on court decision is that in Indonesia you can find there is no legal uniformity. It means that in similar case, yeah, in District Court Surabaya, Jakarta, Medan, and etc. In similar case, then you will find a very different decision. So this is a challenge for research of the based on court decision. So once again, it is important to start implementing case law with from lecture. So lecture must understand read legal decision text before delivering to the students. Okay, thank you, Pak Takdir Rahmadi. I see my computer here already 4:30, but before I don't want to make any conclusion on this discussion. I just want to inform that you can check a chat you can find that we in LIP OKP also have a website cons ID. So you can write your article on legal issue in cons ID. And don't forget also to fill in the registration for this webinar. I would like to invite a closing remark from Dean Jan Smits, and then Pak Iman, and then Pak Takdir as a maybe conclusion or recommendation. Please, Dean Smits.
Yes, thank you. First of all, let me say I very much enjoyed this seminar. There are 2 points I'd like to make substantively. What I found very interesting is the debate that we just had about the question whether, what it means to say that a jurisdiction is a civil law jurisdiction or a common law jurisdiction. I do not think that qualification as such leads to any, let's say, normative statements about what the role of the case law should be. What I mean by that is that the qualification as a civil or common law jurisdiction is a qualification that you put onto a specific jurisdiction in view of the characteristics that it has. And the real question here is, I would say, what is the role that a specific jurisdiction like Indonesia or the Netherlands want to give to the role of case law or to the role of the legislature? I tend to believe that in the Netherlands we give a rather large role to the courts, and we trust the courts also with doing that. Whereas what I get from this debate now is that in Indonesia, perhaps it's still the common view that the role of the legislature must be more important, and that therefore it's maybe less important to look at case law. That's one remark that I get from this debate. Second point I like to make is that for me, this whole debate is really about what do we want our students to learn? What do we want to convey to our students when we teach the law? And for me, it's evident that you can only do that by not only looking at statutes, not only looking also at cases decided by the courts, because like I have tried to explain in my talk, it really helps students also to understand what statutes are about, next to the point that it's also relevant because the courts make law. And also possibly look at the role of academics in there, because that's the nice thing about studying law. You also teach students that academics themselves, and perhaps also law students, have a role to play in the making of the law. Like I said, because they criticize court decisions, because they criticize legislation. And that's a triangle that I mentioned, that you have these three legal actors who make the law in something of a, coordinated effort in creating the law. And we must try to show that to our students. But thank you so much for giving the opportunity to give this talk and to participate in this seminar. And let's continue the conversation.
Thank you, Professor Jan Smits. Dean Iman, please.
Jadi singkat saja, jadi kita sebenarnya sudah mengajarkan kasus-kasus di kelas kita di mana di Fakultas Hukum di Indonesia. Hanya saja metodenya mungkin berbeda-beda dan apa yang didapatkan oleh mahasiswa, pengalaman belajarnya pasti berbeda-beda juga, baik antar fakultas hukum maupun di dalam fakultas hukum itu sendiri yang sama. Misalnya di UNAIR dengan dosen yang berbeda mengajarkan kasus, metode, pengalaman yang didapat mahasiswa akan berbeda-beda. Nah, akan lebih bagus lagi kalau tradisinya itu sudah berkembang dengan baik, metodenya yang digunakan sama, tapi meskipun dengan keterbatasan, seperti misalnya putusan-putusan di Belanda maupun di negara lainnya yang sudah punya sejarah hukum yang panjang, tentu perubahan setiap putusan itu bisa kita ketahui. Sedangkan kita di Indonesia ini baru sejak tahun 2000-an aja kita punya akses terhadap putusan Mahkamah Agung. Sebelum itu agak sulit untuk mencari putusan Mahkamah Agung dan perubahan-perubahannya kemudian gitu. Jadi yang utama memang tentu tradisinya harus kita buat dulu untuk case method ini, karena selama ini belum terbentuk, rasanya belum terbentuk. Tapi bahwa case method diajarkan, sudah diajar, hanya saja berbeda-beda metodenya. Terima kasih Pak Radian.
Thank you, Din Iman. Profesor Takdir, dipersilakan closing statement-nya.
Jadi saya ingin menegaskan kepada Bapak Ibu dosen bahwa pembelajaran berbasis kasus tidak menghilangkan pembelajaran terhadap norma undang-undang. Jangan keliru. Jadi jangan dipertentangkan. Tetap belajar. Misalnya unsur-unsur perjanjian 1320. Nah, konsensus kan, sepakat. Tapi apa makna sepakat secara kenyataan? Dilihat dari putusan hakim. Kapan orang disebut sepakat? Kapan disebut wan prestasi? Ini loh kasusnya. Ini perkara-perkara ini. PMH 1365. Masa kasus Prihandono terus yang sudah berabad-abad dari Belanda. Pelajarilah hal baru. Apa saja. Jadi tidak meninggalkan norma undang-undang, tapi justru memperkaya bagaimana kenyataannya. Law in concrete sense. Hukum dalam kenyataannya. Supaya mahasiswanya nyambung juga. Ketika dia mau jadi lawyer, mau jadi hakim, jaksa, itu sudah kuat bekalnya. Mahkamah Agung, kejaksaan tidak perlu lagi terlalu lama mendidik mereka agar siap bertugas. Begitu juga peradi misalnya, personal advokat. Jadi penting sekali. Jangan dipertentangkan. Tapi ini untuk memperkaya. Memahami hukum secara normatif dan bagaimana kenyataannya diterapkan oleh hakim. Bisa juga karena hukum tidak hanya melalui pengadilan tapi melalui putusan-putusan pemerintah, hukum administrasi negara, wali kota, perizinan misalnya. Jadi itulah, jangan mempertentangkan. Tapi itu untuk memperkaya. Yang kedua, mulailah menulis buku dengan cara meneliti tentang telaahan kasus-kasus secara tematik. Misalnya tadi, pemberi bersikap baik, pembatalan perjanjian, syarat-syaratnya menurut putusan hakim. Apa? Kan begitu. Tipikal, kapan disebut bersalah, memperkaji dan seterusnya. Nah, jadi mulai dari dosennya, kalau sudah ada buku, mahasiswa bisa baca buku, baru diperintahkan mereka langsung cari kasus. Tapi kalau langsung loncat mencari kasus, mempelajari kasus, berat bagi mereka. Saya kira demikian. Jadi butuh waktu memang dimulai dari dosennya dulu. Memahaminya. Terima kasih.
Thank you, Prof. Takdir. So, from Pak Iman, he said that actually we already teach case law, but one of the challenge is a tradition, how to develop tradition to teach based on case law. Second, from Pak Takdir Rahmadi is he repeat that first it change your mind that it is not necessary conflicting between civil and common law, and as a lecturer you have to conduct research and provide your students with sources based on case law. That's all from those two previous speaker. We are at the end of the session. I would like to invite Professor Awe Heringa to have a comment what LIP can do to let's say to develop a tradition in Indonesia law school to teach based on case law? Please, and also you may have closing remark, Professor Awi.
Yeah, Radian, thank you very much for giving me the floor. First of all, I'd like to thank the speakers and the participants for being with us, and the honourable speakers to give such wonderful talks and be responsive and open to questions. It was very clarifying for me, and many issues were touched upon. So there's only a few things which, not as a conclusion, I would make as a couple of remarks. And I think the first is that we may have to distinguish between, it has already been said, also in some ways, we have to distinguish between how we do it and what we do. And the case law method is a kind of methodology as to how to try to teach the law through cases and making cases at the origin of teaching law, as in the United States to a large extent, which is inherently linked in that country to being a common law system. And I think in civil law systems, the methodology has been changed a little bit, or to a large extent, since we started from teaching the law from statutes and from that perspective and the large qualifications, but gradually have grasped to see that case law is highly, as Jan Smits has indicated, highly important in also forming the law and making the law known to us, and elaborating on the content by the lawmaker who willfully allowed the courts to do so, or simply because a lawmaker by definition is lagging behind the facts. The laws are made and then suddenly we have the internet. And before the laws have been adjusted to the internet, cases go to courts in order to solve all kinds of issues about stealing the Wi-Fi connection of your neighbor. So there is a necessity for courts to step in and to also form the law. Also, because courts simply cannot refuse to give judgment. You give a judgment one way or the other, by denying the claim or by accepting the claim, by convicting a person suspected from stealing Wi-Fi, or not acquitting the same person. And those cases have an influence on what the law is. And at the same time, they give examples for law students to get a grasp as to what the law is, how it could be interpreted, and how later on, as lawyers, they can work with the statutes aided by court cases. So I think it's important for the courts, and also from a constitutional perspective, I would say we generally distinguish between three branches of government: the lawmaker, the judiciary, and the executive. And we recognize in many countries that the judiciary prevails over the executive in administrative court cases, and that in many cases the courts also decide cases, and with constitutional court systems the courts even prevail over the lawmaker. So that makes the judiciary a very important factor also, I think, to study. And then the how is left to the methodology employed in a specific country, the case law method, or any other method that includes students to be able to work with statutes, yes, and the structure of the law and the system of the law, but also with case law. And the how, I think we hope with the LEAP OKP project to work further on the how, and also on the what to do, and also how to work when courts do not make available a ratio decidendi. A possibility, as has been suggested, might also be then to, with students, try to imagine a ratio decidendi. How would you as a student write down a ratio decidendi for this specific case if you were the courts? And then you can see with the students that different students might come up with different ratio decidendi. And then you have a discussion and you prepare them for becoming a lawyer, becoming a judge, and becoming a critical lawyer. So I really liked this event. I hope you can work further with more events in the near future on similar topics, and maybe a more advanced webinar on the same topic on methodology and case law. In one way, that's one of the few benefits of COVID. This webinar business has grown. I would have loved to see you in practice in a real meeting, which is much more humane in a sense, but I think it is also much more easy for us now to organize these events and have all of us here in the same event for a couple of hours and being enabling all of us to have this discussion. So we look forward to organize many more of these events. And well, we let you know, please register with the organizers in Airlangga, and then I'm happy and sure we will meet again in the near future. Thank you very much for all the speakers, and thank you very much for the organization.
Thank you, Professor Awe. Thank you once again, and my appreciation to all speakers for sharing your valuable knowledge. Terima kasih Pak Profesor Takdir Rahmadi. Thank you Professor Jan Smits, and also my appreciation for Jan Smits for wearing batik, yeah, Indonesian. Yeah, we proud about it, yeah. And thank you, Dean Iman. Also, thank you, Dr. Shasha Hart, program coordinator of the LEAP OKP. And of course, you can check your email that we will update about our LEAP OKP activities and law Faculty of Law Universitas Airlangga. Once again, thank you very much, and I hope that we are all in prosperous and healthy in this pandemic. Thank you. Selamat sore, selamat siang in the Netherlands. Terima kasih. Bye.
Bye. Thank you very much. Radian, see you tomorrow.
Yes, see you.
Thank you very much.